One of the Trump-era rules that the Biden administration did away with was the public charge rule, which let the U.S. turn away some immigrants who couldn't prove they could get by in this country without public assistance. But that was not the end of the rule, as Alexia Stanbridge reports from our Washington bureau.
Just because the Biden administration wants to drop the Trump-era public charge rule doesn't mean the states agree. And the Arizona Attorney General Mark Brnovich told the Supreme Court today that the states should be allowed to press the charge if the feds won't.
From the other side, even the people from California state acknowledge that states generally should have the ability to intervene when the federal government won't do its job.
Brnovich said the government did not do its job last year when courts blocked the public charge rule. Instead of beginning the complex process of doing away with the policy, the Biden administration just let the court's ruling stand, effectively killing the public charge rule.
There literally was 4 Court of Appeals decisions that were floating around out there, and then the Biden administration took the unprecedented step of basically dismissing all those cases after the U.S. Supreme Court had granted certiorari in the cases.
But Justice Clarence Thomas asked why a new administration should not be allowed to adopt new policies.
The new administration often changes its position in cases. So what's different from this case in which the administration declines to appeal an adverse ruling?
Justices appeared skeptical of Brnovich's claims, pressing him repeatedly on whether there were better ways for the state to pursue its case. But Brnovich said he's cautiously optimistic.
They had a tough time justifying, explaining what they did, and quite frankly, it was a little sneaky, and I think the justices saw that.
The Supreme Court is expected to issue its ruling by this summer. In Washington, Alexia Stanbridge, Cronkite News.
That states could face $1 billion in additional costs without the public charge rule in place. But a Justice Department attorney called that claim just wrong. In the year the rule was in effect, he said just 5 of the more than 50,000 immigrants who applied for a change in their immigration status could not meet the public charge rule.